Welcome again, everyone. Our third and final panel for this symposium, which I have renamed Exclusion, More Exclusion in the Administrative State. Professor Tani of my beloved Berkeley is going to talk to us for about 20 minutes on what the OCR Dear Colleague letter has to do with the Violence Against Women Act of 1994 and the Supreme Court's partial invalidation of it in 2000 in U.S. against Morrison. And then Professor Pasachoff is going to speak to us for about 10 minutes in response, and then I will open it up for Q&A. So Professor Tani, it's great to see you, and welcome.
Thank you so much for that introduction, and thanks to you all for letting me participate remotely. This is kind of the ideal way to participate in a symposium because I can always pretend to go into labor or lose my internet connection if anybody asks me a hard question. So to introduce my paper, I'll just say first off that, like everybody here, I conceived of this paper before the November election. The backdrop today is very different. I think our focus though remains critical. So as I see it, the symposium is asking scholars of administrative law and executive power to pay attention to the experiences of historically marginalized groups, as well as to issues of inclusion and equality. So my particular contribution is about a group of women at the center of recent events, recent protests, and that is women, and particularly women who care about sexual violence. And my precise ad law topic is the Department of Education's campaign against sexual assault on college campuses, and that's via its authority to enforce and interpret Title IX. So I'll be talking specifically about the department's Office for Civil Rights. I'll use the acronym OCR. I suspect that everybody in the room is pretty familiar with this ad law controversy, but to just give a brief review. So in 2011, OCR issued a controversial Dear Colleague letter. So basically it reminded colleges and universities that failure to respond to sexual violence could create a hostile environment for students, and that would be a violation of Title IX. Title IX, of course, is the 1972 law prohibiting federally funded educational programs from discriminating on the basis of sex. And as with Title VI of the Civil Rights Act, failure to comply means loss of federal funds, so no small penalty. Since issuing the 2011 guidance, OCR has not, in fact, terminated any institution's funding, but it has opened hundreds of investigations, signed numerous resolution agreements. Some of these investigations stemmed from student complaints. Some the agency opened on its own. And in a departure from past practice, OCR has publicized the institutions under investigation. So that has effectively raised the stakes of noncompliance. Part of the controversy here is over tactics like that, but it is also about substance. So many institutions have discovered that OCR's 2011 guidance is not consistent with what they had been doing. So for example, they found that their channels for reporting sexual assault were not as clear as the agency wanted, that their procedures for adjudicating responsibility were not sufficiently protective of alleged victims. You've all probably heard about the controversy over the preponderance of the evidence standard of proof. So that's a contrast to the higher standard, clear and convincing, for example, that some universities had been using to adjudicate responsibility. But here's what I would say is indisputable, is that OCR's actions have prompted institutions to shift resources towards the issue of sexual assault and to issue much clearer and stronger policies on unwelcome sexual conduct. Before I get into the paper's argument, I'll just say a few words about why I got into the topic, why I think it's interesting. So a bit about me. I'm actually a historian, pretty shy about commenting on current events, but this is an administrative law controversy that's really captivated me. I'm the product of a college, Dartmouth, that continues to really struggle with institutionalized sex inequality. At my current institution, 2 deans in recent memory resigned in the wake of sexual harassment charges. And in recent years, I've been an avid consumer of a lot of really good scholarly commentary on OCR's campaign. And I think that literature has been interesting because it reveals these tensions among some of academics' most cherished values. So due process, equality, free speech, democratic accountability. And I would say that many academics have actually landed in the critical camp. So they recognize that sexual assault is a serious problem. They're concerned um, about sex discrimination, obviously, but they dislike OCR's use of informal guidance rather than notice and comment rulemaking. They see an agency using public shaming and the power of the purse to get its way. There's sort of been the allegation of bullying. Some critics have raised concerns about whether this is really the agency's business at all. So they say, is this really about educational resources, or is this about what happened during hazy, alcohol-infused sexual encounters between adults? And then finally, I think some associate OCR's campaign with a sort of toxic culture of political correctness in which we infantilize our students and encourage them to feel victimized by anything that challenges them. So I would say that I come to this really respecting and appreciating those critiques, but also feeling as a historian like we've missed a sense of context here. So in my reading, critics have portrayed OCR's actions as aggressive and dangerous in ways that they say are fundamentally new. And they imply that OCR is, guided too much by present day pure politics. So part of why I wrote this paper was to try to build some historical and institutional perspective into the current conversation, and to then use that context to try to suggest some other avenues for research. So the paper that I wrote advances in three parts. I'll do the same in the talk. So by way of overview, very quickly, what those parts are. Part one, the bulk of the article is really about historical context. So I connect OCR's campaign against sexual assault to the fate of other legal efforts to treat freedom from sexual violence as a civil right. So as Neil said, most notably the Violence Against Women Act of 1994, the Rehnquist Court's invalidation of that act in 2000. But my point here would be that those who fought for that act didn't forget about its promises. So one of the main takeaways of my paper is that for at least some advocates, OCR became an alternative to Congress and the courts, a vehicle for vindicating a right that they had come to see as fundamental, but that other institutions had failed to protect. That historical and institutional context then suggests, again, some fruitful avenues for scholars to explore. So I would say to date, I think we've been focused perhaps too much with conventional ad law questions about compliance with the APA, about the due process rights of accused students. So in part two, I argue that we should pay attention to a broader phenomenon, which is administratively created rights. So by that, I mean people using agencies to advance the kind of rights claims that we commonly associate with courts and Congress. And then the final part of my paper tries to get a little bit more specific about the kinds of questions that I think we should be asking. So I offer three specific questions, some preliminary observations, and basically all of these are about implications. So about what kind of right we end up with when we proceed through administrative channels and what might be the costs and the benefits. So that's the overview. I'll now go into each of these parts, spending the most time on the first. So the historical claim. The historical claim, again, is this. So OCR's campaign against sexual assault on college campuses, I would say, can be understood as the latest front in a long and hard-fought war by women and their allies, and that is a war to make freedom from sexual violence a nationally recognized civil right. So to be sure, I think many people in and around OCR really believe that the issue purely is educational equality, full stop. I'm not claiming to know what actually has motivated agency actors, but my claim is more about the aspirations and the disappointments that have essentially structured the landscape in which the agency is working. I think some people in this room have probably lived the history that I'm about to describe, so it feels a little strange to call it history. But for the younger folks, so here's the story, and it starts a lot earlier than 2011. It could probably begin with Reconstruction. I'll start early 1970s. So for me, a good starting point is, again, early 1970s when the concept of sexual harassment entered the mainstream. So sexual harassment was, of course, hardly a new phenomenon, but it was in the early 70s that feminists named it a problem. By the mid 1970s, some feminists have gone a step further to argue that, in fact, sexual harassment was already illegal, at least in workplaces covered by Title VII. So the feminist theorist Catherine McKinnon powerfully advanced this view, so did EEOC Chair Eleanor Holmes Norton, and by 1986, so did the Supreme Court. It did not take long after that for feminist scholars and advocates to begin framing sexual violence more generally, so again, not just sexual harassment, as a matter of civil rights, whether that violence occurred in the workplace or in a private home. So Catherine McKinnon made that connection by emphasizing the message that the government officials send when they tolerate sexual violence. So in her words, rape with legal impunity creates second-class citizens. And other scholars really helped her hammer home that claim by documenting the impunity. So by showing that neither tort law nor criminal law really did much for victims. Indeed, state and local legislators, and police officers, judges, prosecutors routinely placed obstacles in victims' paths. So from that scholarship, from the sexual harassment precedent, it was not a dramatic leap to ask federal lawmakers to recognize sexual violence as a civil rights violation. And here's where I come to the Violence Against Women Act. So that introduced in early 90s finally becomes law in 1994. Here's the key point for today. So what I would want to emphasize to you is that feminist scholars like McKinnon were actively involved in crafting the act, and especially the act's civil rights remedy. So the civil rights remedy was essentially an entry ticket into federal court for victims of gender-motivated violence. And more broadly, it was a statement. It was a statement about what the federal government promised to people within its borders. So the act declared that all persons had the right to be free from sexual violence. The next phase of the story is judicial pushback. So again, we have kind of the recognition of this robust new right, and then we have another institution of government, the judiciary, pulling back from that. So that was apparent first in the realm of sexual harassment. So in the late 1990s, the Supreme Court limited victims' ability to recover damages against schools under Title IX. But I would say even more salient is this 2000 decision, United States versus Morrison. I'm sure you know it, but essentially the court eviscerated Violence Against Women Act. It found that neither the Commerce Clause nor the 14th Amendment gave Congress the power to enact the civil rights remedy. Post-Morrison, I would say, is when things get really interesting in terms of our interests in the administrative state. So January of 2001, last day of the Clinton administration, literally, OCR issued informal revised guidance on sexual harassment. And in that guidance, OCR told schools that the court's interpretation of Title IX in the private right of action context did not govern OCR's dealings with schools. And indeed, it suggested that OCR would hold schools to a higher standard. Now, the incoming Bush administration quickly buried that guidance, but I think over the next 10 years, it became clear that advocates were aware of some potential here. So they were aware of what the agency could be doing. I'm referring here to people like Diane Rosenfeld, who had once worked for the Justice Department's Violence Against Women office and had since begun lecturing at Harvard Law. People like Daniel S. Carter, head of the watchdog group Security on Campus. So again, these are folks who know about the law, know about OCR's role, and are in a position to informally advise college rape victims. They were doing exactly that. Meanwhile, sexual assault scandals were abounding in the 2000s. Many involved college athletes. Many involved deplorable cover-ups by their institutions. And part of the lesson learned there was that private lawsuits, yes, were an option, but they were not an option that often worked very well for victims. And meanwhile, Congress appeared to be an unlikely source for reform. We come now to 2008, to the election of Barack Obama. The treatment of women and girls was, of course, a signature issue for his White House. You have Vice President Joe Biden, who, of course, was a moving force behind the Violence Against Women Act. And meanwhile, you have Congress still unlikely to do much on the issue, but you have OCR being now potentially more available. And I would say forces external to the White House mattered here too. So in the paper I write about a series of exposés in 2010 by the Center for Public Integrity. That's a nonprofit reporting outlet, which basically just documented all the ways that colleges and universities fell short when it came to dealing with sexual assaults on campus. So basically, around late 2010, early 2011, the timing was perfect for OCR to issue clearer guidance on this issue and to get tougher on enforcement. The final point that I want to make as part of this historical narrative is about the grassroots movement that developed alongside OCR's efforts. And again, I think that scholars tend to give this short shrift. So I'm thinking about groups like Know Your Nine, you've probably heard of, or End Rape Campus. And movement actors, people in these groups really do place OCR's work in the context of a long-term civil rights battle. So one that is not just about education or campus environments, but about citizenship more generally. So here's a 2013 quote from one prominent organizer. She says, "Our goal is to show that there is a pervasive culture of sexual assault which needs to be addressed on a national level." That same organizer describes her organization as part of a movement to end gender-based violence. Here's a quote from another organizer. She says her group's goal, this is in 2014, was, quote, "a national civil right to freedom from sexual violence." So again, talking much more than about education. She continues, "After the Supreme Court's attack on the Violence Against Women Act, Title IX was, quote, "our only national model." So bottom line here, I think there are deeper and older aspirations running underneath OCR's recent campaign. For at least some people, the right at issue isn't just about equal access to education. It's about equal participation in civic life. It's about how vulnerability to sexual violence affects women's ability to enjoy all the benefits of citizenship. And given the unavailability of Congress and the courts for advancing this vision, I don't think it's surprising to see people looking to a federal agency. So as I see it, now moving on into other parts of the paper, I think foregrounding that history is itself an important contribution because it suggests that the convictions underlying OCR's current campaign are not going away. So I think that's true even under current political leadership, perhaps especially under current political leadership. So scholars and even administrators can tell women that Title IX doesn't carry a from sexual violence, but that won't necessarily make these kind of claims go away. But as I said earlier, the paper also tries to do a bit more than just offer historical context. And that is that I also try to offer some concrete questions that I think scholars should be asking about the administration of Title IX. I derive these questions from a larger body of historical work on the development of rights claims in and around administrative agencies. So here I'm referring to part 2 of the paper. I'll be very brief in this particular comment. The gist of part 2 is just to say that various legal scholars working on various time periods and policy areas have now seen something similar to what I'm describing. So they've identified the crucial role of agencies in advancing novel rights claims. So I have examples from workplace civil rights, welfare rights, language rights. And although each example has some unique elements, in each instance you see an agency having the tools to recognize a new right and doing so at a time when other lawmaking institutions seemed less available. Now, I wouldn't go so far as to say that administrative rights making or rights articulation is a good thing. So another takeaway from the paper is that we really don't know enough about whether it is or whether it isn't. So as legal scholars, this is the final part of my paper, I want to ask, well, how do we get to the bottom of that? So if a phenomenon worth exploring is the use of administrative agencies to advance these novel rights claims, what are the right questions to be asking going forward? So I pose three questions that I think ought to be pursued, and I'll just briefly say a word about these three. So the first question I would pose is, what happens when agencies become vehicles for these novel rights, but when actual rights claims have to proceed through regulated entities rather than through the agency or a court? So in the case of Title IX and this right to be free from sexual violence, that's exactly what happens. So here's how it would technically work. So the key decision maker here is the student's college or university. That's what I mean by saying the right gets mediated through the regulated entity. If OCR was made aware of an individual claim and made aware of a flawed institutional response, it could find the violation of the individual's educational rights, but it couldn't formally adjudicate the wrongfulness of the alleged sexual violation. It couldn't discipline the perpetrator. Now, plenty of commentators have sort of assumed that in the wake of OCR's campaign, surely student victims must be getting what they want. Surely accused students must be getting disciplined at higher rates. I would say we actually have very little reliable evidence of that. We need more research on what's actually happening. Meanwhile, though, I think we do have plenty of evidence from a related field, and that is workplace sexual harassment, to suggest that rights claims tend to wither and die when they proceed through regulated entities. Again, that's been the findings of research on workplace sexual harassment. That research also encourages us to ask whether administratively created rights may have some particular weaknesses or vulnerabilities because of how easy it is for regulated entities to create appearance of honoring rights without actually taking steps to discourage rights violations. So that's a phenomenon that sociologists call symbolic compliance. Again, creating the appearance of honoring rights, but not necessarily doing much to discourage rights violations from happening in the first place. So I would say we need more research on whether that's happening in the Title IX context. The second question that I flag for study is, how should we think about administratively created rights in a world of easily changeable administrative interpretations and enforcement schemes? So I would say when we think about rights, we tend to think about durability as a defining feature. But we also know that administrative interpretations, especially informal ones, those are changeable. So what might that mean for this aspirational right to be free from sexual violence? I think that's probably the biggest question post-Trump. I don't have answers right now. I do have a few observations. So one observation is that although informal guidance is relatively easy to change, old guidance may well leave a lot of institutional baggage or machinery in its wake. So I would say going forward, we're going to need more research about what's happened to those hundreds of new Title IX coordinators, right, that popped up in recent years, many of whom have an interest in keeping their jobs. Another observation is that although an agency can change its interpretations, it can change its enforcement strategies, it has much less control over the rights consciousness of regulatory beneficiaries. So here's students. If enough students have come to believe that they have a right to be free from sexual violence, then I would say changes in agency policy and practice may not matter as much as we expect. The third and final question that I flag for study is this. So what happens to rights when they are pegged to the incomplete jurisdiction of a federal agency? So OCR's jurisdiction is limited technically to educational institutions that accept federal funds. So if advocates hope to use OCR to advance a broader vision, again, a vision of freedom from sexual violence as a national civil right, they need to grapple with that jurisdictional limit. It is, of course, possible that college campuses become a foothold, a place where norms take root, where norms spread, but it's equally possible that we all get used to the idea that students just deserve better than everyone else, in which case we're no longer really talking about a universal civil right. So I'll close here, and just as you can probably tell from my phrasing, I'll say that the last part of the paper is really more of a provocation, an invitation. My modest hope for today is that I've prompted you to think a bit differently about a big recent ad law controversy. And I'll say I just hope you'll join me in asking some fresh questions about the practical workings of our administrative state. So thank you very much for listening.
Thank you. Thank you very much, Professor Tani. Now we'll hear from Professor Pasachoff.
So hello, everybody. I'm very glad to be here. I'm going to echo without restating all of the thanks to everybody. I'm going to acknowledge the incredible weirdness of my responding to a person on Skype who I can sort of see, but she can only hear me. So if I'm looking at the video and trying to engage her and that feels weird to you, it feels a little weird to me too. So I'm just going to say, hi, Karen. It's great to hear your thoughts, and it was great to read your paper and to engage with your work a little bit here today. All right, so So Professor Tani has given us has a lot to think about. So she's given us both a fascinating historical context as well as an institutional context. And she's a historian, and I'm a scholar of institutions, so I'm really going to focus my remarks on the latter part of her paper, although I'll circle back a little bit and say something about the long scope of history at the end. I'm going to do this for one other reason, too, and that's because I think part of this debate about OCR's power has been extremely narrowly focused on this particular controversy, or maybe if you want to add in the transgender Dear Colleague letter as well, that particular controversy. But actually, these are much broader questions, not only in OCR itself. So they've actually issued closer to 40 or 50 Dear Colleague letters over the course of the Obama administration, and we could be talking about all of those. But of course, they also interpret rights in complaint processing and so forth. And then, of course, the questions that Professor Tani asks, I think, are broader ones, not just about even the work of OCR, but are about questions about administratively created rights in general. So she asks us to think about three potential weaknesses associated with what she calls these administratively created rights. And so just to recap what we just heard, the first one is that they are mediated or filtered through different entities, sort of the regulated entities governed by the agency and the statute in question. Second one is that they can be changeable. They're more changeable than maybe how we traditionally think about rights. And then the third thing is that they are incomplete because they maybe extend only as far as the agency's jurisdiction. And so my response is really going to be in the form of yes and. And what I mean by that is that I agree that these are all descriptively limitations of the kinds of claims that she's described, but I'm not convinced that they are unique to administratively created rights. And so part of what I have done in thinking about her paper is just come up with a bunch of different examples of how the exact same limitations she suggests and the questions she asks us to think about apply to rights, just plain and simple, created by Congress, whether or not there's any agency involved at all. And the same is true by rights created or interpreted, or whatever fancy lawyer word you want to use, for what courts do, whether in the statutory or constitutional context. So I guess the bottom line is that I think the research questions she asks us to think about are important, and we should definitely think about them, but we should expand the institutions and the fields that we think about them in. And then I also think that if you take this sort of functional equivalence among who's creating the rights seriously, then in the context of the current moment that we're in, then I think taking the long view, and this is where I would then circle back to the historical point, this sort of functional equivalence matters. All right, so just a few examples of what I mean for each of the potential limitations that she describes. So So mediated rights. So she asks us to think about all these limitations that might be associated with mediated rights. So, how seriously do the regulated entities take the mediated rights? Do they treat complainants fairly? How do they shape the rights holders? Or do they just engage in what she's asked us to think about as symbolic compliance? And again, those are great questions. And there are plenty of statutorily created rights that have to be effectuated through regulated entities that protect the right where there's just no agency involved, where the right is itself created by Congress. So for example, even if we had no EEOC, Title VII would still be working through the fact of employers having employees. So to take another example of a statutory right that I have written some about, the federal special education rights that are offered under the Individuals with Disabilities Education Act. So that's a statutorily created right that's got to be mediated through school districts, classrooms, individual schools. And there's no agency that you take a right to, or at least at the federal level. So it's just the function of that particular form of right is to be mediated through the entity. And I also think that this is not just a function of Congress creating a right, but courts are involved in this kind of setting forth rights that have to be mediated through an entity as well. So taking the Title IX cases that sort of gave rise to the administrative interpretation here to begin with, I actually think there's a little bit of disagreement maybe about whether the Supreme Court's Title IX cases are all seen as limitations and cutbacks on Title IX. I think some of them actually could be seen as expansions of that right. So, for example, the idea that the Title IX sex harassment prohibition extends to peer-on-peer sexual, that's not at all clear. Well, I'm not sure that I actually want to say that because there's a clear statement rule that I might be wanting to cling to there. But in any event, I will just say there is a hard-fought defense, or dissent rather, that says that it's not at all clear. So that sort of looks like an expansion in some way, and that's a right that has to be mediated through the school. So there's nothing sort of special about what OCR has done with its Title IX expansion that the Supreme Court itself wasn't already engaged in. And then I also don't think, so I've just given you examples from of statutes right now, but I think the same thing could be true for constitutional rights. So thinking about the right to attend a desegregated school, for example, the big downfall of that right is that it had to be mediated through institutions. And those were not institutions that wanted to be engaged in the granting of the right. So I guess I just think this concept of mediated rights is a completely fascinating one, and it's the research agenda that Professor Tani has posed for us is rich and has tons of places to go with it, and it's a much broader research question than limited to just agency-created rights. And I could just make similar comments about changeability and then about the incompleteness. So changeability. So Congress changes rights all the time. At the moment, we have something of a right to health care. If we were having this conversation in another month, I don't know. So I also think that the changeability of agency-created rights, depends somewhat on the agency's choice of policymaking form. So the reason why all these rights are so up in the air is because they've been done through guidance documents. And had they gone through notice and comment, it would be a lot harder to unfurl them. So the agency chose its own limitations in some sense by putting these in guidance documents. To the extent that different administrations have different enforcement priorities, and so enforcement might be another aspect of the changeability, that's also not disconnected from Congress with enforcement budgets that can have incredibly strict directions through riders about what the agency can and cannot enforce. And I think courts are involved as well in thinking about the changeability of agency enforcement strategies. So a case mentioned in a lot of the papers, although we didn't actually talk about so much today, but is Alexander versus Sandoval. And so the Supreme Court's cutting back on the ability of private enforcement of Title VI and analog statutes. So that's another example of sort of the changeability of rights in that context by courts. And then, of course, substantive rights, so not just on the enforcement doctrine. So, we did talk a little bit about cutting back on rights under the Voting Rights Act. But so that's just another example. Courts can create rights. We've mentioned Obergefell, and courts can kind of cut back on rights. And so that's, again, I think the research questions are important about what does it mean to be living with a changeable right? When are rights changeable? What's the extent? But I think we have to think much more broadly about the institution, the trans-institutional nature of the changeability of these rights. Okay, last thing on incomplete rights. So even assuming that agencies do nothing more than implement the plain text on the page rather than creating something new, I think my argument would be that they're limited not because the agencies have something especially limited about their jurisdiction, but because this Congress has given them incomplete rights to effectuate, right? So without going through in great detail now, all of the different civil rights statutes are structured in different ways. So first, they all cover different protected categories. Not every protected category that you might think should be covered in a civil rights statute actually has a home in a civil rights statute. They all have different scopes. So Title IX just covers federally funded educational institutions. Title VI covers federal funding no matter the kind of institution. The ADA applies to private places of public accommodation. So they all they're just incomplete no matter how you look at it. Relatedly, the anti-discrimination framework itself is incomplete. So we have talked a little bit today, Professor Johnson's paper this morning asked us to think more broadly about what it means to have a right of inclusion. And so I think if you think about administratively created rights in the broader context of what does it mean to have a right to anything, I mean, that's, the anti-discrimination framework itself is, if you want to have other sort of social, economic forms of inclusion, that's another aspect of sort of incompleteness. The tiers of scrutiny that Professor Ross asked us to think about this morning, that's another example of incomplete rights, again, this time put forth by courts via a constitutional doctrine. And so something that would be unconstitutional as applied to some groups isn't unconstitutional as applied to other groups. That's incomplete, and we could find that problematic in a whole variety of ways. And if you push too hard on the question of incomplete rights, I think you run right up into the incomplete rights that are written into the founding documents, right? So we have these inalienable rights for some people, and so you are immediately just confronted with the question of Dred Scott and Seneca Falls, and you are brought right back to the idea that at some sense, our country is founded on the nation, on the existence of incomplete rights far before we had an administrative state, far before we had anybody thinking about, administratively created rights. That's just the structure and function, and it might not be a good thing. And in fact, it's not a good thing. And so the questions that Professor Tani asked us to think about, I think, are the right questions. But I think we ought to, again, interrogate them in a much broader way. So the very last thing I'll say is that my expansion on Professor Tani's research questions brings me right back to the very same place. And this is where I think that as she ends up, and I think this is where her historical lens is particularly important, because the idea is that rights holders and people who want to be rights holders are not going away. And so when you take the long view, what her paper gives us is this notion that she has this wonderful phrase in the paper about different pockets of the state. And the idea that she leaves us with is that rights holders and people who want to be rights holders will continue to press their claims in whatever pockets of the state are available. And so I think the project for us today, and the project really has been something we've been thinking about all day, are what are these pockets of the state and how can we think about them more broadly? So we have talked a little bit about the role of courts and maybe the tensions between courts getting back in the game or not. And I think the more and more outrageous certain executive branch actions look, the more courts might step up their game. I think the same might be true for Congress as well, even a Congress of the same party. I think maybe we're seeing a little bit of that in the last few days, but I am out of the prediction game. But I would also say that thinking about different pockets of the state should invite us really to think broadly about different pockets of the state. So here are a few that I'm especially interested in. So when I taught education law this fall, I did a whole big unit on school boards as a wow, we had to talk a lot more about the legal power, and I'm just going to say right now that everybody in this room ought to think about running for school board. Union contracts, that's an important sort of place that we have not thought enough about as a kind of place of advancing rights. And you can give up on them in one historical moment, but I think Professor Tani has asked us to take the long view. And so taking the long view, school boards were not such an awesome place for rights in the 1950s and 60s. And in fact, it's part of why we've ended up through, going through to VAWA and now to Title IX. But history shouldn't mean that we have to leave everything behind because they didn't work in a certain context. And so we could revisit that. Another pocket of the state that I'm extremely interested in is civil servants at OMB. And so there is, for example, a set of documents that these civil servants at OMB have promulgated through formal notice and comment called the Grants Planning Circulars. They have been in place since the 1960s to manage the flow of federal money. They were redone in the Obama administration. And there are several, and this really is a technocrat for justice kind of set of documents. To echo Professor Johnson's comments from the morning, I presented on this at that Duke conference on civil rights a few years ago, so that's sort of in the vein. But so there are several places in this extremely technical set of documents that govern in a trans-substantive way what all federal funding recipients are allowed to spend their money on. And there are several places in this document that have expanded opportunities for women in STEM. Now, that seems, one, narrow, but also substantive, but in a variety of ways allowing certain sorts of overhead money to be spent on childcare at conferences. That's actually kind of important. And so thinking about where are all the pockets of the state that are hidden at every level, local, state, and federal, that we might begin to think about, and certainly that rights holders and people who want to be rights holders should begin to think about. I think that's part of the project that Professor Tani's paper asks us to think about and that I think all of us who are here today are engaged in. So I will stop there and I look forward to comments.
Well, thank you for that excellent set of remarks. So Professor Tani is more of a splitter and Professor Pasachoff is more of a lumper. And it sounds to me like they come together on taking the long view, that you may not be able to win the present, but you still have a chance of winning the future. Otherwise, right, why care? Let's hear from you folks. Questions? Yes.
I can, yeah. I can hear you too. I'm zooming in right now.
And thank you, Eloise. So I have just, I guess there are comments, questions. This is such an interesting project. I think that I would think that. Just something to think about. I mean, I'm really interested in what we call rights. I mean, I just have that as a question. I think a lot of us are using the terminology, and I think in political theory, it means something specific, and I'm not sure any of these things we're calling rights are really rights. So I just raised that as a question. You have to respond to it. The other thing is, before you Skyped in, just so you know, we were talking about whether or not these things were changeable or not, and the fact that there's a sort of political economy that gets maintained around things like the Title IX Dear Colleague letter, that is based on the fact that institutions have incentives to comply and sort of and motivations that go well beyond that go beyond complying with the specific directives, but it furthers their own needs. So it could be that they don't want students on campus to complain. It could be that they actually want a campus free of sexual assault, that they want women and other marginalized groups to feel included, and so those things sustain themselves. So just wanted to point out that we talked about that, and we can have further conversations about that. Then the last 2 points just to think about is that you talked about whether or not the fact that these are limited in some ways and that they apply to the public sector, I think is what you were saying, and not to the private, right? I actually think, so that's quite expansive already that they apply to the public, but one of the things you might want to think about are just sort of notions of diffusion. Universities are always comparing themselves against each other, and so are all institutions. It's not limited to Title IX. This is the sort of trans-substantive point. It is actually true in Title VII with human resources officers. I mean, it's a mechanism we should be thinking about more broadly. Those of us who study the interaction between private actors, the state, administrative agencies, that there are sort of private standards and private incentives to comply and to distribute information and to diffuse norms that are not just based on how much it covers in a technical sense. And then the last point was, it's kind of a broader point. Someone who's sort of studied similar dynamics with regard to Title IX and in housing, I just wonder sometimes what it all adds up to, right? The stories that we're telling about all of this sort of creation of rights in the administrative state. So I think these stories go across agencies, as you've seen, or go across contexts. And so that's very powerful. But there's a debate in the political science literature as to whether or not agencies are really leading and innovating, or whether courts are really doing all the work and civil society is responding to what courts are doing, and then they put pressure on the agencies. And so I just wondered if you, at this point, had thoughts on that. I mean, I see all of those, I see more of an interplay, and a lot of the reason that this has any import in this is possible, the mechanism that you're describing, is because we have hybrid forms of enforcement in civil rights, right? We can go to courts, we can go to agencies, and then there's congressional oversight, and that you need all of that in order to be able to sustain these mechanisms. But it's not clear to me that agencies are usually the innovators in much of this rights creation. So I just wondered if you had thoughts on that, on any of those things.
Yeah, those are great thoughts. And Eloise, thank you so much for that comment. Just Oladi, on the last point, I would say that the person that actually kind of got me most intrigued in this topic is the political scientist Shep Melnick at Harvard. And one of the arguments that he has made is that he thinks that it used to be that civil rights were much more of that kind of, a creation of multiple institutions collaborating. He describes a kind of leapfrog process, like I think you're thinking of, where the courts are saying something and agencies are maybe responding or innovating a little bit, and then the courts do something else, and it's much more of a dialogue. His argument with regards to Title IX, and I think he's right, is that agencies are now, at least OCR seems to be kind of going it alone more. So the courts have taken a particular position. Congress, he would say, is gridlocked, and here's an agency. I think he has a kind of more negative view of it. He would describe it as sort of a rogue agency, just kind of going again, like deviating from this institutional leapfrog process and developing the law on its own. So I think it could be too that that we're seeing a new paradigm right now in recent years in terms of the way that institutions are working together to create and define what rights mean. In terms of the political economy around Title IX, I think that's really an important piece of this, and I haven't looked into it as much as I should. But I think an important part of the story that scholars don't pay enough attention to is the fact that institutions were actually, I think, asking for guidance. So some of them, at least, I think, felt like they didn't have sort of legal or institutional cover for things that their students were asking for. And it's actually not a bad thing for them to be able to say, oh, look, the feds made us do this. So I think there's something to that too. So I think there's a lot more learning that we have to do about, like as you said, sort of who's leading here, who's following, what's the political economy, to what extent are institutions driving this, to what extent are students driving it. The only other thing I'll add is that I think kind of regardless of who's leading it, I do think that the agency voice becomes important to the extent that they're giving these rules the valence of law. So I think part of what is a right has to be, that it's something, that we recognize it because it has the valence of law. Some authoritative entity, whether it's a court or Congress or an agency, is saying, this is what the law guarantees you. So thank you so much for that comment.
Yes.
It's Carrie Abrams from UVA. Yeah. It'll come to me, but hi. How are you doing? So my question is, first of all, I love the paper, and I had not really thought of the OCR guidance in light of Morrison to this extent. So this was really, really helpful, and I think you're right. So my question isn't really a challenge so much as a complication that I think might make it even more interesting. So in thinking about the sort of paradigm or the scope of what would have been considered sexual violence at the time of the passage of law, it seems to me that we've expanded our idea of that significantly, and I think that's really interesting. So thinking back to what a lot of the rhetoric around the time of VAWA involved, a lot of it had to do with state law enforcement, both police and prosecutors, not taking it seriously. But a lot of the rhetoric now on college campuses goes a lot further, and a lot of the things that have been really controversial about OCR's interpretation have been about taking the definition of sexual violence and expanding it quite a bit. And I guess I mean in many ways. One is affirmative consent as being, as opposed to force or lack of consent, right? One is the idea that the entire community is harmed, and so broad reporting is necessary even if the survivor doesn't want to report. And another is the preponderance of the evidence standard, which if you think back to what the private right would have done, it's all there, right? It's all there if you think back to VAWA. And it all could have come out of that had that been upheld, but I don't think that was the main kind of public focus at the time, the way it is now. And I don't know what to make of that. Like, I don't know if it's, you talked a little bit about, is educational setting different? Like, I don't know if it's possible that we're largely talking about very young people whose parents are very interested in their safety and are in a particularly vulnerable position being on their own for the first time. And so we're thinking of the right to be free from sexual violence to involve the right to experiment with all sorts of things without fear, and maybe that's a different context. But I also just wonder if our public consciousness about sexual violence has just changed and morphed and expanded over this whole period, despite the Morrison decision. And if that's so, it's not just that this is popping up in a new place, it's that it's continuing to gain public traction and then pops up in a new place. And then maybe even though the Supreme Court victory, defeat you might think of as a defeat, exists, it didn't actually stop this movement from continuing. And just add to that the fact that the people who are demanding this the most, the students, don't remember Morrison. Right? So this isn't the same people asking for the same thing later, even though their advocates may be some of the same people. It's the public consciousness asking for something later, but with new actual individuals as the mouthpiece.
Yeah, that's a really interesting comment. I actually do think if you do a kind of genealogy of some of the activists here, there actually is, Catherine McKinnon, right, is teaching these students that become then at the forefront of the movement. So I do think there is a kind of institutional memory that in some cases is being transmitted forward. And then I guess I would also say that I think you're right that something is different in terms of what the students, how they understand sexual violence and what they think kind of is beyond the pale. But I would also say that I think part of what they're asking for is the same thing that people are asking of state legislators, right, in terms of reforming the law of sexual assault more generally, right? They want changes in the definition of rape and sexual assault. They want, affirmative consent is not just an idea that is limited to campus communities. I think that for some people, that's a reform that they would like to see spread more broadly, so that people, not just students, would have a right to sexual autonomy that is that is broader. And that actually allows me to circle back and push back a little bit on one of Eloise's points, which is I do think there's something here about incompleteness or lack of uniformity that is a vulnerability of trying to pursue a rights agenda through an agency. Because I do think, so if it is true that some of these advocates and activists aspire towards, freedom from sexual violence as a national civil right, and they're sort of taking like half a loaf now by getting it on college campuses, I do think that you are essentially leaving behind people who don't have access to those spaces. So people who graduate out or who are not students, you're essentially saying to them, well, if something happens to you, you go ahead and use this state and local machinery that we all know is flawed, and you go ahead and deal with these rape and sexual assault laws that we all think are sort of too narrow. So again, that's sort of what I meant by this incompleteness or lack of uniformity. And I think that risk is real to the extent that energies are being channeled to this agency with limited jurisdiction. But thank you so much for that wrinkle. I think it's really, really helpful and productive to think about it.
Well, unfortunately, we are out of time, but I want to thank Professor Tani and Professor Pasachoff, and I want to thank our very able students at DLJ for putting this symposium together.
Thank you so much for allowing me to participate.
But they're now slimmed down. You'll be happy to know my remarks because of all the good points that have already been. Yeah. All right. So, fair enough. So anyway, most of what I was going to say has already been said. But there's one new thing that was added, and then one thing that I think I can help to frame. So a new thing that was added is we're accustomed to thinking of agencies and agency heads who act aggressively and as people who are not really paying attention to the statute. They're just out there as rogue operators. Now, don't take my word for this. James Landis, the architect of the SEC, one of the most important people in the history of the administrative state, wrote, here I'm reading from his book from 1938, "One of the ablest administrators that it was my good fortune to know, I believe, never read, at least more than casually, the statutes that he translated into reality. He assumed that they gave him power to deal with the broad problems of an industry, and upon that understanding, he sought his own solutions." And they added, "There's an enormous difference between the legalistic form of approach that from the negative vantage of statutory limitations looks to see what it must do, and the approach that considers a problem from the standpoint of finding out what it can do." This is the vision of the heroic agency head who doesn't care about the statutory language and is just going to go out there and do a lot of stuff. And what's interesting is some of the papers here are highlighting the ways in which agency heads can do a lot of stuff actually within the four corners of their statute. And the thing that particularly brought this to mind, the reason I went and grabbed this quotation during the beginning of Karen Tani's talk, was what Kai Feldblum was saying, hey, if I just look at my own statute, that gives me a whole lot of room to do a lot, because it might be that the agency isn't going as far as its statute allows. That's a very different vision of aggressiveness, a very different vision of sort of activism, as it were, sort of like the point that has been made in the constitutional context. Gee, if we took privileges or immunities actually seriously, how broad might that actually be as a constitutional vision? But we don't. Well, as an agency head, you can say, hey, I've got this statute. Let me see what this statute actually allows me to do. And you don't have to go rogue, as it were, the way that Landis was advocating, and basically the way that nobody today would. This would be close to an impeachable offense to say that now. And this is what he proudly said. And he was the guy. The second thing that I want to highlight is something that it's been a thread throughout, but I just want to highlight because it's important, I think, to highlight. A lot of the papers here today are about agencies, as we've talked about, as laboratories of democracy, agencies as loci of experimentation. They're acting on their own, they're pushing boundaries, maybe within the statute, as I just said. I'm not saying necessarily they're going outside the statutory bounds, but not fully controlled by the president. The idea is they are engaged on their own in pushing some boundaries, whether or not it might be that the president is on board or is even aware of what the agencies are doing. So this is an old story that we should just keep in mind. This is a story of democratic accountability, or the lack thereof, right? Because now we've got a situation where we know Congress can't control agency heads, see Boucher versus Sinar, and now we know if it's in reality that these agency heads are experimenting, then who's minding the store? And we know at the other extreme is the Unitary Executive, right? And the Unitary Executive, let me remind you, is that the president can rein in anyone, by the way, whether or not they're in an independent agency or not, or as Justice Scalia would call them, independent agencies, right? And so the extreme version of the Unitary Executive is that Donald Trump can call up Janet Yellen tomorrow and order that she lower interest rates, and if she doesn't, he can fire her, because everybody in the executive branch is part of the Unitary Executive. Great advantage of that is it allows for democratic accountability, but of course it ends this pluralism and ends this experimentation. It ends the agencies as laboratories. So the obvious point here, this symposium is all about the glories of experimentation, and there's been, as Alati's article forthrightly noted, she noted there's an elegiac nature of her paper now, because there was a certain set of assumptions about what agencies would be allowed to do that seems like, gee, that may not be in the offing. But that doesn't actually answer the question of which way you want to go on this question of experimentalism and greater independence and laboratories of experimentation versus executive control, both for the far future, but also even for the more immediate, for the more immediate period of time. And so, yes, we're always trying to think transsubstantively in terms of long-term approaches, but we don't necessarily have to give up so much right now, even as a policy matter, just in terms of our preferences, on this question of, well, I guess we don't want them to be engaging in experimentation. Maybe not. We might have a whole set of fears about that, which are understandable and reasonable. But it's always as compared to what? So let's be honest. Most of the people in the legal academy weren't expecting this outcome and are dealing with a new reality. But doesn't answer the question of how you want that administrative state to be set up. It might be that this is a stronger argument than ever for the kinds of approaches that the papers here that we're talking about today would advocate. So with that, I do want to say, when this proposal originally came across the transom, I'm the DLJ advisor. Said, boy, I think this could be a really interesting idea. I think it's been great. I think the DLJ has done a great job. So all praise to everybody here who made this happen. Those of you who came in as commenters. I personally think it's been great. And although there is this elegiac quality, in some ways, the subject of this conference is actually more useful, more valuable than ever, given the kind of pivots that we may be facing. So I don't know if you have any further. If there's anything else you want to say beyond that, other than I really do want to say thanks, especially to the DLJ people for putting together a great conference. Thanks to everyone.